was born in Shreveport because my older brother was born at a home in Halton, and my mom said never again. So after about 7 days at the Tri-State Hospital in Shreveport, I was taken home to Benton to join my older brother George. Benton was a parish seat of Bossier Parish, and we had a school, we had a courthouse, we had a service station, we had a doctor's office, just about everything a little town could need. I spent my elementary and high school days in Benton, played sports there. Benton was too small to have a football team. My senior graduating class was 3 boys and 7 girls. Well, I graduated from high school during the middle of the Korean War. Just about everybody I knew was going into service. I had a friend that went to North Korea, and he went out on patrol with 4 other guys. Only 3 of them made it back. I decided I didn't want to be a foot soldier in North Korea, so I applied for Naval ROTC program, and I fortunately received a scholarship from the Naval ROTC, which paid tuition and books and $50 a month, which pretty well covered most of my college expenses. And I picked University of Oklahoma as the nearest school to home and applied there and was accepted. And so I went to Oklahoma and got involved in student politics there. My dad was elected official in Bossier Parish. He served as a tax assessor for 28 years. Historically, I had a great-grandfather that was a sheriff in Georgia, so politics kind of ran in the family. I always tell people that in choosing a career, I looked around Benton and I saw you could be a school teacher, or you could be a service station operator, or where the real excitement was in the courthouse, where the lawyers and the judges hung out. And I decided that I would like to be a lawyer and one day go into politics. Going to LSU and going to the LSU Law School was beneficial from a political standpoint, but that was not my major concern. When I was in college at Oklahoma, I was really concentrating on student activities. I got my lessons done, I graduated with honors, but I did not really devote myself to studies. When I got to law school, it was completely different. I didn't go to the fraternity meetings. I studied and tried to do the very best I could, knowing that I wanted to be a good lawyer, and that would be the best stepping stone to move into politics at a later time. So I didn't pick LSU because I'd make political contacts there. I picked LSU because I thought it was the best law school for a Louisiana lawyer. I finished law school in 1963. I had been interviewed by a number of firms, but some in New Orleans and other places, but I wanted to come back to Shreveport, and I've learned about the possibility of applying for a federal judgeship law clerk position, and I applied for one with Judge Ben Dawkins Jr., and he hired me. I made some famous salary, I guess, then about $500+ a month, which was real good pay back in those days. Judge Dawkins had been on the school board, Caddo Parish School Board. He was a stickler for ethics and doing things right. His father had been a federal judge. Seemed like everybody knew Judge Dawkins. There was a lot of unrest in Shreveport, and Judge Dawkins ended up being in the middle of a lot of it. The way he was in the middle of it was there were a lot of lawsuits filed for desegregating the schools throughout Louisiana. In Shreveport, Judge Dawkins was the only federal judge for that area, and of course he had the responsibility of deciding these desegregation cases, and he ruled in favor of integrating the schools. After that time, he became a pretty lonely man. It seemed like a lot of his friends resented his ruling. The atmosphere in the community was very, very volatile. There were suppression of the blacks, and the liberal whites would join in marching. We had our tough commissioner of public safety, George Dartars, and he and his men used some brutality on the black preachers and the other blacks that were marching and trying to bring about certain civil liberties that they did not enjoy. At that time, young people may not remember, but at that time, a black person could not drink out of a water fountain where white people drank. They couldn't go to restaurants and sit where white people sat. They didn't go to the same school. They went to a black school. I remember an instance when I was in Baton Rouge, actually, and I was working I was working full-time, but it was before I started law school, and I was working for the tax assessor's office, and a man and a little black boy came by the water fountain, which is a white water fountain, and the little boy wanted some water, and his dad says, "You can't have any." That really affected me, and I gave the little boy some water. After serving as a law clerk for Judge Dawkins for a year, I was employed by Robert G. Pugh. Bob Pugh was a very industrious attorney. He was a sole practitioner, and so when I went to work for him, there's a two-man firm. Bob was a workaholic. He got to work sometimes, well, quite frequently, 4:30, 5 o'clock in the morning, and stayed till late afternoon. I had a wife and 2 small children, and those hours were a little trying for me, but I did not try to get there that early in the morning, but I certainly tried to get there at before 8, well before 8, and to stay late. We had office hours on Saturday. During those days, it seemed like everything was different compared to what it is now. The cases that I'd work on, I'd use a manual typewriter to prepare my notes, and then I'd mark it up and give it to the secretary, and she'd make things look real neat on her IBM Correcting Selectric, maybe. We had no big fancy copy machines. We used mimeographs. Anyway, Bob Pugh had the practice of accepting anything that came in the door. It didn't matter what the subject was. We had one case that involved a potential admiralty claim in Lake Hamilton, and Bob and I, neither one had studied admiralty, but he thought it was a good case to take. So he called Claytor's bookstore in Baton Rouge and said, "How many books you got on admiralty?" They said 7. He said, "Send me 7, all 7 of them." So we studied admiralty. I had occasion to really learn how to work hard, and no matter what came up, we took care of it. After practicing law with Bob Pugh for 13 years, I decided to organize my own firm. We had hired a young attorney, John Hammonds, who was working for Pugh and Nelson at that time. And I told John, I said, "Look, Bob Pugh's got much better status than I do, more experience and more clients, but I'm striking out on my own. If you want to join me, fine. If you want to stay with Bob for a better financial situation, fine." And he chose to come with me, which I was real pleased with. And so John and I were partners from the very beginning. He'd only been out 1 year, but I made him a partner. And it was a challenge that I think many young lawyers ought to consider taking. I was elected to the state senate in 1979, took office in 1980, and it wasn't long after I took office that the issue of forced airship in Louisiana was brought home to me very vividly. We, in Shreveport, Bossier, we have a big Air Force community, and many of these people have come to Louisiana from other states. The Air Force officers frequently had wills that left everything to their surviving spouse. And often they unfortunately would have more than one marriage, and they may have children from a prior marriage. They may be estranged from those particular children or the former spouse. The forced airship law, in effect at the time I was elected to the Senate, provided that if you had 3 or more children, those 3 children were forced heirs for 2/3 of your property. When people from Barksdale Air Force Base that moved to Louisiana from some other state learned that you had to be concerned about whether your children would claim their forced airship right if you left a will, and that they could claim 2/3 of what you owned, this really upset them. They wanted to know that when they died that their wife could have everything was a normal course, the normal thing that they've chose. Forced airship, in addition to giving forced airship rights of 2/3 to 3 or more children, there was forced airship for parents too. If you had no children, parents were forced heirs. There was problems with doing wills that would provide the best tax advantages when you had to concern yourself with this 2/3 going to potentially going to children. In 1981, I believe it was, I spoke to a group and made the commitment that I would work to repeal forced airship law as it existed in Louisiana. So I started filing bills to repeal the law and also joining efforts to modify it. So over time, while I was in the legislature, we reduced forced airship to a maximum of 1/2 of the property that you owned with 3 or more children. We changed the law so that if a property was being inherited by a spouse, that you could leave the use of that property to that spouse, even though it was being claimed by the children in the forced airship. After I got out of the legislature, the battle continued, and today it's my understanding that the forced airship is down to a situation where the only people that are forced heirs are children 23 and under, or people who are totally incapacitated. I have some concerns about that, because when you write a will, you know whether you have a child that's 23 years or younger, but you don't know whether one of your adult children that are older than that are going to be disabled. So there's real question marks when you do a will in Louisiana and you have children as to whether or not you can do freely what you want to with your property. When I was elected to the Senate in 1979 and took office in 1980, lobby was rolling strong. They had defeated labor on right to work, and they were trying to reform what they call reform workers' compensation. They had a bill that was modeled after a bill in Florida, and the workers' compensation bill was going to come to my committee that I served on, Labor and Industrial Relations. So I studied it carefully and learned that the Florida bill had a number of protections for injured workers which were omitted from the Law B bill. And so I became concerned about that and talked to not only business but also to labor. Labor was headed up by Victor Busey, head of AFL-CIO, and business was led by Ed Steimel, head of the Louisiana Association of Business and Industry. As it turned out, the bill came up, I believe, in 1981, and when the bill came up in 1981 in my committee, I was prepared to join with labor and the trial lawyers to put a bunch of amendments on there. As luck would have it, having served on the committee, I learned more about the amendments than anybody else in the Senate. And when the bill came to the Senate floor, the committee chairman and labor and trial lawyers asked me to handle most all of the amendments to the bill that they wanted on there. There were about 20 of them. So I handled 20 amendments to the bill, all of which were favorable to labor and an injured worker and opposed by lobby. The amendments passed in the Senate on a very close vote, and the bill went back to the House, and they chose not to put it in conference committee, and the bill was killed for that year. Governor Treen appointed a committee to study the workers' compensation bill, and in the interim, and I was put on that committee. The labor was going all out to kill the bill, and lobby was going all out to pass the bill. I kept Governor Treen advised of my position, and I had the ability to talk to him because I was one of his floor leaders on the legislation the administration was sponsoring. For his benefit, Governor Treen never tried to cause me to back off on anything that I thought was right and fair, and he just said, "Well, thanks for keeping me advised," and watched the ongoing process. He called a special session primarily to consider the workers' comp bill. Lobby wanted to see if they could convince me to be for the bill, and so they scheduled a meeting with me at the Capitol House in Baton Rouge. When I say they, there's about 18 different industry groups led by a group of lobbyists, and we worked way into the night on amendments that I would agree to and that I wouldn't agree to. My vote would not have been a deciding thing, but I was a main voice from making the amendments passed previously. We negotiated into the night, and I was able to get them to agree to various things which were beneficial to injured workers. And then I agreed to be a co-author of the bill, and the bill passed with a great majority. So I became known as a switch hitter, being one time for business and then another time for labor and trial lawyers. The legal profession is a great profession. I've enjoyed the practice of law. There's so much variety. I cannot imagine anything else that I'd rather do. I think that the fact that there's a lot of criticism of attorneys is just something we have to live with. If you're involved in litigation, the people on the other side are more likely to disagree with you and not agree with what you're trying to do. But just have fun. Be courteous. Be courteous to the opposing counsel. Be honest and truthful and upfront about what your dealings, and usually being that approach will reward you by having similar reaction from the opposing counsel.